Hi, everyone. Thank you for joining us today. We see that people are still logging in, so we're going to wait one more minute for people to log in, and then we'll get started. Thank you for joining us, everyone. We're going to get started right now. We're just aware of the time, and we want to respect the fact that everyone's dedicating an hour of their day to join us for this important briefing. My name is Steve McDonald. I'm the VP of Communications and Marketing here at UJA. We're so pleased that you've joined us because from UJA's perspective, these virtual sessions are a really important opportunity to provide an update to our community on what we're doing to fight anti-Semitism and what people can do to be a part of the cause. We're very pleased to be joined with a fantastic panel today of legal experts within our community who are at the forefront of combating anti-Semitism through the legal system. This is an initiative under the umbrella of CIJA's Legal Task Force. So those of you who've been on these previous calls would know that UJA's advocacy agent, the Center for Israel and Jewish Affairs, which is the advocacy agent of all of the federations across Canada, in addition to CIJA's important work, to lobby government, to speak out to media, to engage influencers within Canadian society, CIJA also maintains a legal task force, which brings together dozens, in fact, over 200 lawyers donating their time pro bono to ensure that community members who are experiencing anti-Semitism have access to complementary legal supports to enable them to stand up for their rights and also to hold those who are spreading anti-Semitism accountable. I won't say too much more because we've got a fantastic panel today. I'm going to start by introducing our first panelist, and that is Mark Fryman, who serves as co-chair of CIJA's Legal Task Force. Those of you who've been involved in these issues in the past or been following the fight against anti-Semitism for years will be familiar with Mark. Mark is previously known for having served as Deputy Attorney General for Ontario. He served as lead commission counsel at the Air India Public Inquiry, as well as for the Canadian Human Rights Commission's proceedings against Ernst Zundel, the Holocaust denier. He's been widely cited for his knowledge and his insights into constitutional law. Mark went to the University of Toronto, but he also holds a PhD from Stanford University. Previously served as law clerk to a late Chief Justice, Brian Dixon. So this is someone who has been highly involved in the fight against anti-Semitism and the fight for human rights more broadly. And with that, I'm very pleased to invite Mark to join us on camera to share a brief overview of the work that the Legal Task Force is doing to stand up for the rights of our community.
Thank you, Steve. Thank you, Steve. It's a pleasure to be here. Round about the second week of October, a bunch of us got together under the auspices of CIJA with a modest proposal. The modest proposal was that we were going to get together as many Jewish and non-Jewish lawyers as possible, and we were going to offer pro bono legal services to anyone who had suffered anti-Semitism in our community. It didn't occur to us exactly what it was that we were getting ourselves into, but we approached CIJA, CIJA approached us, and we ended up with what I think is the world's largest pro bono law firm. As Steve mentioned, we have well over 100 lawyers who have volunteered their time and their energies to help us to fight anti-Semitism through the legal system. Our approach has been twofold, two streams. One stream is to assist people who have been confronted by anti-Semitism by giving them advice and, where necessary, legal representation where they need someone to help them with their court case. The second approach that we have is what's sometimes called lawfare. That is to organize initiatives in the court that will vindicate the rights of the Jewish community in a proactive manner. We've launched a number of initiatives. You'll hear more about them from some of the panelists who are going to follow me, but two very interesting cases that we've dealt with so far have been the case we launched in Superior Court against the Government of Canada with respect to the recommencement of funding to UNRWA. And the basis of our case is that Canada is violating its own legislation against support of terrorist organizations. So that case is proceeding. There's going to be a hearing later this month where the Government of Canada has asked for our case against them to be struck out. That will be a very interesting hearing later in the month. We have a second case that we've launched before the Ontario Human Rights Tribunal against PSAC, the Public Service Alliance of Canada, where we are claiming that they are violating the human rights of their Jewish members by some of the stances they are taking, which violate the rights of their Jewish members not to be discriminated against on the basis of religion and national origin. That will be proceeding further. I know my colleague Steve Frankel will be speaking at greater length about cases that we have started against the Metropolitan University, and others will be speaking against initiatives that we have going in the school sector. I know there'll be questions that people will have about our initiative in general, and we'll be answering those questions in the question and answer segment of these proceedings. In the meanwhile, I just inform people, if you have encountered anti-Semitism, do contact us at CIJA-LTF@CIJA.ca. I'm hoping that's going to be flashed across the screen. Similarly, if you're a lawyer and you would like to volunteer your services, CIJA-LTF@CIJA.ca, and there it is on our screen. Or sorry, it's just LTF@CIJA.ca. And with that, I'm going to turn it back to Steve McDonald for the next panelist.
Thank you, Mark. And on behalf of all of us, thank you for all the work that you're putting into this, and to all the colleagues on this panel. I know it's a tremendous dedication of personal time that you've made, but I also know it's making a world of difference for the significant number of people that have been helped by the LTF. I think the last time I checked, it was over 300 people have benefited from that pro bono legal support. So it's really a tremendous difference it's making for those who are experiencing some of the worst anti-Semitism in our community right now. With that, I'm going to look to one specific area of the Legal Task Force's work, which is the area of campus advocacy and standing up for the rights of university and college students. Stephen Frankel has been very, very involved in this. Stephen, I'm going to invite you to share some insights momentarily. Stephen is a litigation lawyer and partner at Davies, Ward, Phillips, and Weinberg LLP. He's very much involved as co-chair of the campus committee of the legal task force. So Stephen's been very much in the trenches on the campus side of this. Stephen was lead counsel in the food vendors case. For those who are aware of food vendors, this was a food vendor promoting blatant anti-Semitism right here in Toronto. And in that case, I believe it's before the Human Rights Tribunal in September, in addition to the work that Stephen's been doing to support Jewish students. So with that, Stephen, what can you share with us about the fight to protect the legal rights of Jewish students on university campuses?
Sure, happy to speak to that, Steve. So I'm sure everyone who's logged on to this call knows that campuses have seen an explosion of anti-Semitism and have at times been almost a literal battleground in the period since October 7. That will have escaped no one's notice. We know how sensitive and important an issue that this is for everyone in the community, and for very good reason. Everyone's either an alumnus of a university or sends their kids to university or has friends or other family members at university. And even if you don't, we all care about how young minds are being shaped on campus, and we all care about how young Jewish folks are being treated on campus, having regard to the fact that generally they're not financially independent, they're vulnerable, and they need to rely on their peers as well as their professors. They are relying on grades for their future career prospects, and it just puts them in, as I said, a very vulnerable position. So we all care about that, and for very good reason. And I'm not going to try to pull the wool over the eyes of anyone on this call. I think we all know how grim the situation on campus has been for the last, coming up on soon enough, a year. So what is the role of the legal task force on campus? What role have we played? And I would say we played sort of a dual role, or a twofold role. First, on more of a micro level, members of our task force and of our committee have been helping individual students deal with day-to-day issues as they've arisen, complaints and difficulties in their dealings with university officials, family members, faculty members rather, other students, student unions, faculty associations and unions, you name it. We've been doing a lot of that, as well as helping Jewish faculty members themselves or allies who are employees of universities. And in doing so, we've provided practical advice and guidance to literally dozens and dozens and dozens of students and faculty members and university employees. That's been a labor of love and a time-intensive effort that has involved many committee members and volunteers spending a lot of one-on-one time with students, faculty members, parents of students, all in an effort to help people through this very difficult time. And in doing that, we have drawn on the expertise also of colleagues of ours on the legal task force who are labor and employment lawyers and who are criminal lawyers as necessary and appropriate. I would be remiss if I didn't mention the close collaboration that we've had with our partners at Hillel, Ontario, who have boots on the ground on many campuses across the province and who provide support to Jewish students on a daily basis. So we work closely with them and look forward to continuing to do so. So that's sort of track number one, is the more micro level, which has been most of what we've done, and although may not get the headlines, is probably the most impactful thing that we do. Second track or aspect is we've always kept on the table the option of more macro level action to safeguard the rights and interests of Jewish members, Jewish community members who are on campus, as well as to affect change and to, frankly, if we have to, persuade, including through legal routes, universities to modify their behavior and the approaches that they've been taking. That's what led to the lawsuit that Mark Fryman referred to a couple of minutes ago against Toronto Metropolitan University here in Toronto. That litigation is being led by David Rosenfeld of Koski-Minsky, who is a member of the campus committee of our task force. So kol hakavod to David for all the work that he's done. CIJA has also intervened, or did also intervene, in the University of Toronto's successful application in Superior Court here in Toronto before Justice Conan to enjoin the unlawful encampment at that campus. The decision that which granted University of Toronto's application has in turn, in our view, contributed directly to the dismantling of encampments at other campuses in Canada. I should say that we remain open to pursuing or supporting the pursuit of additional legal action as necessary and appropriate. We know how much energy and excitement there's been for doing this, probably since October 7th or October 8th. But it is important to understand some basic limits, which lawyers on this call will likely intuitively understand. Others, hopefully this is a bit of a, if not an education, then an information session. We have at least two important limits. First, there needs to be a viable plaintiff in every piece of litigation, viable claimant or plaintiff or applicant, depending on the nature and the form of the litigation. Usually, if we're talking about campus, that's a university student. You're talking about really kids who are 19, 20, 21, maybe a bit older if they're graduate students. It's asking a lot for somebody of that age and stage in their life to put their name on a statement of claim or on a pleading, and to be at the helm of what will inevitably be a very public piece of litigation, something that will always come up when they're Googled for the rest of their lives, all at a time where, as I said at the outset, they are financially not independent and relying on being able to get good grades in order to move ahead and achieve everything they want to in their careers and lives. So it's asking a lot, and we owe it to students to look out for them and to inform them of what they are taking on in terms of personal risk when they agree to become plaintiffs. So that's the first practical limit. The second is there needs to be a viable claim. Again, we know how much people care about anti-Semitism on campus, but everybody needs to understand that not every instance of anti-Semitism on campus is necessarily legally actionable. We all have to bear in mind that campuses are places of free and sometimes vigorous expression, and that universities typically defend the important principle of academic freedom. We grapple with these issues all the time in evaluating complaints and issues and potential claims, and there is no magic wand that we can always wave to make something legally actionable just because we don't like it. As the 2024 to 2025 academic year approaches quickly, we're mindful of the need to be proactive in our approach to campus going forward. And that will include in dealing with the likely return of encampments. I don't think anybody should be under any illusion that they're gone forever. So we're planning already on potential legal responses. Planning as well on the likely return, which we've started to see a little bit already, of efforts to institutionalize and entrench BDS on campus. And we're keeping our eyes on other tactics and strategies that our opponents will likely adopt, including based on things that they see on campus in the United States. Before I turn it back over to Steve, Steve McDonald, who I think will introduce Naomi, I should mention that, of course, there have been a couple of setbacks more recently. Everybody will likely be aware of the release of the McDonald report concerning Toronto Metropolitan University, and even more recently, quite an appalling agreement that's been entered into by Windsor that exceeded to the demands of the leaders of the encampment there. So yes, we are aware of those and other issues, and yes, we are studying potential legal responses. So please rest assured that people are looking at all these matters very carefully and considering what can be done about them. And with that, I'll turn it back to Steve McDonald.
Thank you for that, Stephen. Again, thank you for all of the time you've put into this and all of the intellectual energy you've put into standing up for our students. It's top of mind for so many people in the community, and these are very, very serious issues that are going to impact the future of our country. And so it's really, really important that we draw a line that we're not going to stand by as a community while these things happen on campus. And so thank you for everything you're doing to stand up for students' rights. I'm now very pleased to introduce Naomi Loweth. Naomi is the chair of the Public Schools Division at CIJA's Legal Task Force. Naomi is an experienced lawyer who received her degree at Harvard Law and subsequent to that clerked at the International Criminal Tribunal for Rwanda, as well as the Supreme Court of Canada, before taking on a practice as a litigator here in Toronto. So Naomi, thank you for joining us. And Naomi, I know I hear a lot from community members who are concerned about the public school situation and what kids, and not just kids, but Jewish staff and Jewish teachers have to deal with. Can you shed some light into what we're doing to take the legal fight against anti-Semitism to the public school sector?
Yeah, absolutely. Thank you. I think the best way to take everyone through what we're doing today is to divide it into 3 headings. So first, I'm going to talk about what we're doing. Second, what are some of the challenges that we're facing? And then third, what we need in order to keep this fight going. It won't surprise you that a lot of the things you heard from Steve about what we have happening on universities is echoed in schools, sometimes even more severely, sometimes less. In terms of what the legal task force has been doing over the last 9 months is first and foremost, we've been trying to help students and families who are experiencing anti-Semitism in the public school system, so the elementary schools or high schools. We're helping them navigate instances that occur where they reach out to us for help. Sometimes that work is being done in conjunction with Pro Bono Ontario. The lawyers on the call will be familiar with Pro Bono Ontario as a wonderful organization that provides pro bono assistance to students or to a wide variety of issues across Ontario, but they have a special program on the education law, and they've created a special sub-program with respect to anti-Semitism in schools. So some of the work we've been doing is still largely been led by and administered by, and the legal work has been done by members of the legal task force under CIJA, but we've done that in partnership with Pro Bono Ontario, which has helped us with some of the administrative help. And also Pro Bono Ontario is really regarded as a very respected organization within Ontario and certainly within the legal community, and sometimes coming within under the auspices of Pro Bono Ontario has helped lower the temperature when some of these issues are raised with school administrators or with principals. What that work looks like in terms of how we help is, first of all, just trying to help families navigate situations. If they want to draw attention to a problem to the teacher or to the principal or a superintendent or another staff member, sometimes it's just helping them have those conversations or giving them tips for how to best to have those conversations. We see a really wide range of anti-Semitism, I think, everywhere in the world these days. But there is a big part of me that still believes that most people actually want to do the right thing. I think most people do not have hate in their hearts, and they often don't realize the impact of what they are doing. So sometimes it's just sitting down and explaining why something is so problematic and helping them get to a place where they can remedy the problem, which is what their legal and ethical responsibilities are to protect our students. And sometimes it's helpful to have someone, a lawyer next to you with that advocacy, either sitting at meetings or helping draft letters. And that is a lot of what we've done. We have had tremendous help on this part of the task force from retired school principals and retired teachers who have been able to give us insights into how best to effect change within the school board system. And having a retired principal sit with you and say, like, this is what you should be saying to the principal. This is how I would have dealt with it as I was a principal, has been hugely valuable. So you'll hear a request for help at the end in terms of more lawyer volunteers, but also if there are members of the community or allies who are in that position as retired principals or superintendents, school administrative staff, teachers, who might be able to help us navigate how things actually work in classrooms, that's hugely helpful. We also, as Steve said, are working with teachers and administrative staff who are experiencing anti-Semitism themselves. This ties in a lot with the union work. And you heard Mark say at the beginning that we've been doing a lot of work in cooperation with unions, which continues to be a big area of concern, really globally, but particularly in Ontario. So teachers and administrative staff who are being discriminated against, who are finding a lack of support from their school system. And then we've also been looking at some of the broader issues within the school board system. So sometimes it's curriculum issues in terms of how certain issues are presented. We sometimes see homework that comes home that would really surprise you in terms of how issues are being characterized. The days, in terms of what days are recognized in schools, and obviously anti-Palestinian racism and the way that that has been adopted, or the lack of the clear way in which that has been adopted by the Toronto District School Board, has been on our radar as we develop ways to try and address it. Often what we want to do is help students make the problem go away immediately. As a litigator, there's a default to almost always want to sue, but lawsuits are long and slow and time consuming and have some of the other challenges that Steve highlighted for you. And we don't want to win a lawsuit in 7 years. We want our kids to be safer tomorrow. So the things that we can do immediately to help affect that have been a priority for us. There are still cases where ultimately legal action is going to be required, and they tend to fall into one of 3 categories. So the first would be where we're bringing a civil claim against either an individual or more likely a school or a school board for their failure to meet their duty and protect students. We also look at complaints again at the Human Rights Tribunal, because of course, race and religion and national origin are protected grounds under our Human Rights Code. And so we are looking at complaints in that venue. And there's also complaints sometimes at the College of Teachers. If there's an individual teacher, and sometimes principals are still governed by the College of Teachers, whose conduct falls below the standard of care that's held, that all principals are held to, then that's also an area that we would explore in the right circumstances where we think that's what's necessary in order to demonstrate the seriousness of what's happened or to affect the change that hasn't taken place yet. We're also looking at wider claims. When I said civil claims, human rights tribunal claims at the beginning, they're often related to individual instances within a specific student or a specific school. And as time goes on, we're seeing that there are certain school boards that don't seem to meet that definition that I believe most people have, which is of wanting to do the right thing. And they really aren't putting the time and energy required into protecting Jewish students in the schools. And so that might be a broader claim against a specific school board for its failure on a widespread basis to protect students and to take the steps necessary to ensure that there's not anti-Semitism in our schools. The law is an imperfect tool. It's not always the right one. So we obviously are doing this, broadly speaking, the legal task force is working in cooperation with, government relations, advocacy, individuals, people within CIJA, other institutions that we have the benefit of working with. Many of you on the call will be familiar with an advocacy group called JEFA, which has been doing a lot of outstanding work in the school system. And we want to keep working cooperatively with them to ensure that we can combine our efforts on behalf of the community. In terms of what are some of the challenges that we're facing, so one of the first challenges that we're facing is getting timely, accurate information about instances that are happening. And that includes information coming in. And so I know in the chat, we've had the link for emails, and also there's an incident report on CIJA's webpage that you can use to report at instance of anti-Semitism. Sometimes we hear about things through rumor, and we work really hard to try and verify them, because if we're going to start taking actions on, on the basis of what we've heard, we need to be hearing from the individuals who are affected by it. And sometimes not through any fault of anyone, stories get convoluted as time goes on. So hearing about accurate, timely information is really important. Statistics are increasingly being relied upon in every avenue that we see. So we hear it when the Toronto Police talk about anti-Semitism, and we hear about it when the Toronto District School Board or all sorts of other organizations all the way up to the national level are talking about what instances there are of anti-Semitism. So it's really important that we all do what we can to enable accurate statistics to be presented so that we can use them for launching claims or for just ensuring that our advocacy is appropriate in those circumstances. As Steve said, it is really difficult to find an individual who wants to become a plaintiff in an action. It is not an easy thing for someone to do in the best of circumstances, and everyone would agree that we are not in the best of circumstances right now. And if you magnify that by being a child who's in the court system, there are sometimes things we could do to protect their identity, but we have to be realistic that it's very possible that their name may come out in the public record. And in addition to all the things that Steve said about the challenge of being in a legal action and just wanting to, get good grades and not wanting to be searchable on Google for the next 40 years, just the people that we're dealing with are kids who just want to belong, and they just want to fly beneath the radar, and they don't want anything special about drawing attention to them. And so to ask those individuals to become plaintiffs in an action is not something anyone would do lightly. And so we're really mindful of what that means to children. I think so much of what's happened since October 7th has fallen disproportionately to our children. And this is just another example of a time when it can be really difficult. Sometimes the challenges that the people we're dealing with at the school boards don't see the problems that we are highlighting for them, that they either don't agree with the perspectives that are being advanced, or they think kids should just toughen up. And those are obviously, challenges that we're doing our very best to try and overcome. I think that as time goes on, the message I have been trying to push is less about anti-Semitism per se, and more about the idea that our schools should be safe for every student, regardless of religious background, regardless of identity, regardless of your views on politics or the Middle East or anything else. Your school should be safe. And I find that when I'm personally interacting with politicians or members of the education community, that fundamental message that every kid has a right to be safe when they go to school resonates best. It certainly echoes what we've been hearing, this real focus on anti-bullying in schools over the last decade or so, and tying it into that language, I think, is very important, and it helps get the attention from people who do want to help. And then the last challenge I would say we're experiencing is that our volunteers are tired. I think, as Mark said at the beginning, no one really knew what this was going to be when we met in the second week of October. But I don't think anyone would have imagined that 9 months later, we would feel like we're just girding ourselves up for the next battle in a long war. And that seems to be where we're at now. So our volunteers are tired. So with that, in terms of what we need, more volunteers if you're able. We can circulate information. I should say that the members of our team have been largely Jewish, but by no means exclusively. And some of the lawyers who've taken on the biggest actions and had the best successes and been really in the trenches working on things have not been Jewish lawyers. And I'm so grateful for the help that we've had from everyone. So this is a widespread call. As I said, not just for the lawyers, though. If there are individuals who have experience with respect to school administration and how best to affect change in that regard, or to just be a sounding board that says, yes, well, a student was suspended, and when they're suspended, the next thing they need to do is have a parent meeting before they come back, so that we know the things we're supposed to be asking for from a school under their own policies in order to ensure that the appropriate steps are being taken. As I said, it's really important to share information. If you have accurate and timely information that you can share through all the means that we've talked about, either by direct emails to us or through the CIJA website, that's going to be really important. The last thing that I would say, this is probably a broader point beyond schools, is that getting involved at community levels in all these organizations is hugely important. We don't have a lot of Jewish school trustees across the province. And I don't think you can just jump immediately into being a trustee if that's something that you want to do. I think being involved at PTAs and on the dance committee and all sorts of other organizations, so that the school administration gets to know you as a parent, maybe before the first phone call is about something with respect to anti-Semitism, that you get to know other parents, that they get to know you. Those things would also be really valuable. So with that, I'll end with, those are the things that I think we need. It won't surprise you that my parents, like many other Jewish parents, I think, are watching this call. So I will end with a short happy birthday to my father.
Thank you for that, Naomi. And now, folks, what we're going to do is we're going to open it up to the Q&A portion of the call. We've received a number of great questions that have come in through the chat. If you do have questions, just go ahead and drop them into the chat, and we'll get through as many of them as we possibly can. I'm going to ask all the panelists to join us on screen right now. And I've taken notes for the call of some of the questions that have come in and some that have come to my mind. So I'm gonna jump right into it and bounce around the panel in terms of the answers we're looking for. But before I begin, I also just want to acknowledge we're joined as well by another fantastic lawyer, Richard Marceau, who is VP of External Affairs and General Counsel at CIJA. Those who follow CIJA's work will be very familiar with Richard. He's often in the media. He's a published author, a former member of Parliament, and also an experienced lawyer. So we're very happy to have your support as well, Richard. And thank you for everything you do to stand up for our community as well in these difficult times. So to our panelists, I'm going to begin with one quick question that I'm actually going to answer because it comes up from time to time. And that is the issue of the lawsuit that UJA has filed against two vendors who are bus companies. This is related to the Ottawa rally that took place last December. Many community members will be aware that, you know, we had organized a whole bunch of buses here in Toronto to bring people to Ottawa, and 17 buses did not show up. I won't get into the details on this call, but suffice to say that we have launched litigation against two companies, including seeking damages for discrimination because of what happened in that incident. Another member of the legal task force, Ellie Mogul, as well as Jacob Klugsberg, have taken this on pro bono. So we're very happy to have legal task force support for that as well. That case is still before the courts. So people in our community have been asking, you know, what's the status, what's happening? I'm sure all the lawyers on this call will attest to the fact that these things take time when they do go before the courts. Naomi made the point about how litigation is a longer term game. It's not a quick fix. So it's not always the right solution. In the case of the bus the bus company situation, we've had no choice but to go down the path of litigation, but it does mean it takes time. We are committed to reporting back to the community as soon as there's a resolution to this case, but we are fighting not only to recover the community's money, but also to send a message that you can't get away with this in Canada in 2024. So with that, I'm going to get right into some of the other questions that were asked. One question that came up, and maybe this is for you, Stephen, or for anyone on the panel, it was really about the campus situation and the balance of free speech versus the rights of students. You made this point earlier, Stephen, about how campus by definition is a place for ideas to clash. But this means that we're vulnerable in terms of being seen to be clamping down on free speech in an environment like campus. Just very quickly, how do we get the balance right? How do we find where the line is between legitimate, even uncomfortable speech versus hateful actions and hostility to Jewish students?
That's a really good question, and is exactly at the center of any piece of litigation that will be launched about what goes on at campus, because we can all, sure as God, I mean, little green apples, we can be sure that that is exactly what any university will say in response to any piece of litigation. This is simply a matter of speech on campus. And it's as simple as that. I think anybody who wants to answer that question could do no better than reading, and it's a publicly available document, reading the statement of claim that has been issued in the TMU matter that I referred to earlier, and that Mark Freiman referred to earlier. See the legal theories and the facts that have been alleged in that statement of claim. That the way I can best summarize it is our view is that, among other things, when a student agrees to go to a university, there is a binding agreement between the university and the student. The student's supposed to receive educational services. The university receives tuition. I'm simplifying things, obviously, but that's at the core of the deal. And from our perspective, part of the deal is that the university will provide a safe learning environment and will apply its own policies and procedures fairly, consistently, and accurately, and not decline either selectively or otherwise to apply them. And so where you have a persistent set of breaches of student codes of conduct in a way that is prejudicing the rights and interests of Jewish students and making them incapable of obtaining a proper education, incapable of participating on campus, you're getting closer, I think, to something that may be an actionable claim. When a student is uncomfortable because a TA is wearing a keffiyeh or is saying Free Palestine or has got a Palestinian flag, that is not going to be something that's legally actionable. Obviously, there's a lot of things that fall between those two ends of the spectrum. I don't want to go much further into this because I don't want to say something that could touch on legal strategy or might be quoted back to me in a legal proceeding. But that's the basic way that I would answer that question, which is a tricky one.
And Stephen, to your point, as with all of these calls, this is an open forum for anyone in the community to hear about what we're doing. But because we're trying to be as transparent as possible and open to the community as possible, it means there are moments where there are things that we just can't say publicly because it's going to impact either the security of the community or, in this case, the legal strategy with some of these issues. So sometimes there are going to be moments where we can't share all the information we'd like to share because we know that people who have very different views on these issues, and in some cases adversaries of our community, can openly access these recordings. So we're very cautious in what we say. But I think you've given us a good framework to understand kind of the balance between free speech versus our right to study as members of a campus community in an environment free of hostility. But with that, Stephen, I just have one follow-up question for you regarding the U of T ruling, because a number of people have asked about this. On the one hand, we were pleased to see that the injunction was granted to remove the encampment, and UJA and CIJA and other Jewish organizations were present in the process as interveners. So we were represented through the legal task force in the injunction process. On the other hand, there were a lot of concerns raised in the community that the decision itself in court indicated or suggested that what's happening at the encampment is not hateful. So some people said, look, this is problematic. And we know that anti-Israel activists are playing up this part of the ruling, trying to say that it's a vindication for them. Stephen, what's your quick take on the U of T ruling and what it means for our community?
Yeah, I'll try to make it quick, but this probably would require a more comprehensive discussion to really go through because again, there's some nuance to this. So let me give it my best shot. First, I hope everybody will understand what role CIJA could and did play in this proceeding and what role it was not permitted to play and could not play. So CIJA was not a named party to the proceeding. The proceeding was commenced by the University of Toronto against, frankly, a bit of a ragtag bunch of respondents. And I'll try not to use language more pejorative than that, pejorative language than that. CIJA was not a party. CIJA, among many other third-party organizations, was permitted to intervene in the proceeding. And without getting into a technical legal discussion about what that can mean, in this case, what it meant was CIJA was permitted to make written argument only. CIJA was not permitted to file affidavit or other evidence. And I stand to be corrected, but I don't believe CIJA was permitted time, or if it was permitted maybe a short amount of time, something like 5 minutes. But I don't even think that we got that in oral argument. So it was really just written submissions. All of the interveners labored under more or less the same restrictions which were imposed by the court with some nuance to it. So CIJA could not put forward any evidence about, for instance, what the meaning of from the river to the sea is, what the Arabic version of that is, and what that means. We could not put forward that evidence because we were not permitted to do so. Okay? That's the first thing that people need to understand. The second thing is the University of Toronto framed its case in seeking relief, not as a matter of the meaning of speech and whether or not it is anti-Semitic, but as a matter of property rights, right? As a matter of trespass. The case from the perspective of the University of Toronto was, we own this piece of property. It is sort of a common ground on campus. It is being occupied unlawfully. It is being unoccupied unlawfully to the exclusion of others who might want to use it. It's not proper and it's got to stop. The University of Toronto, I suppose, could speak for itself, but the strategy that was adopted was not really to engage on any of the other matters in any really meaningful sense. So there, again, was not a whole bunch of evidence led about the meaning of certain types of speech. The ruling that was made on the basis of the property rights argument, on the basis of trespass, and the application of the University of Toronto was successful. It is true that Justice Conan made a number of comments along the way in his decision about some of the speech issues, and not necessarily the most helpful comments in certain senses. We can all read the decision and understand that. I would not interpret any of his comments as definitive findings on the meaning of any of those types of speech. At best, I think I would read them as saying, I'm not in a position based on the evidentiary record that's been put before me to make a determination that these things are anti-Semitic in nature, right? That is effectively what he has said. None of those comments are critical to the decision. They're not legally binding on any other judge in any future matter. And again, people can rest assured that if it comes time to litigate in a different case on a proper evidentiary record, what from the river to the sea means and what from the water to the water Palestine will be Arab means, we will do that. And although I'm sure our opponents will rely upon Justice Conan's decision, it will not be binding on whatever judge or decision maker has to consider that issue. So I understand the community's disappointment with some of those comments, but I would encourage people to read them and understand them in their proper context, and with an understanding of what role we could and could not play in that proceeding. So I've spoken for longer than you asked me to, probably, Steve, but that is the best I can do in the limited amount of time I have to answer that question in a straightforward manner.
No, that's super helpful, Stephen. Thank you for that context. I want to switch over to the public school sector for a moment. Naomi, we've had a number of questions. I'm going to package a couple of them together for you right now around how we support students. So I want to preface this by saying, and I think all the legal task force panelists would agree, the reality is that the fight against anti-Semitism is so complex and constantly changing. We need, as a community, to have as many tools in the toolbox to deal with it as possible. In some cases, the tool is we need to lobby for change, either a government policy change or legislative change or whatever it may be. In other cases, it's about engaging law enforcement and showing them what the needs of our community happen to be in a given moment. In the case of the legal task force, the work that you're doing to support students with and their families with legal guidance and support kind of goes hand in hand with the political engagement with the education ministry, as well as the grassroots engagement, JEFA and other groups in the community that are directly engaging their trustees. Naomi, can you speak to kind of how the legal piece, the legal task force's work kind of dovetails with that political engagement? I mean, Naomi, do you recommend or suggest that an individual is having a challenge in their school, for example, reach out to trustees, their local trustee or a prominent Jewish member of the board? So that's the first question. How do we work with trustees who are supportive and who really do care about these issues? How do we work with them and ensure that the legal work is complementary? The other part of the question, if you can address, is about looking beyond Toronto. We've talked a lot about the Toronto situation in terms of campus as well as the TDSB, given what's happened, but there are a lot of issues in different boards across the province. So is the legal task force supporting people in different boards, and kind of how does that look?
Sure. Let me start with the second one. I grew up in a town where the people in my family were quite likely the only Jewish people that the people who lived around us would ever meet. So I have a lot of passion and compassion for people who are in smaller Jewish communities. By no means is our work limited to Toronto. Those of you on the call are probably sick of me asking that question. What are we doing for the smaller communities? Because it's been a big part of my own life. So we are working with school boards across the province. We get calls regularly from students who are in Belleville or in St. Catharines, Niagara, Halton, and we do everything, the same work that we're doing here, we're doing there. Sometimes we pair them with lawyers in their own cities, sometimes we don't. We do whatever is necessary in order to help them. And I think the students there, who are one of maybe 2 or 3 are the only Jewish students in their community, sometimes feel this particularly acutely. So we're very sensitive to that. We're also working in cooperation with other provinces. We had a call last week with a lawyer in New Brunswick, and we're trading ideas. By all means, we want to cooperate across the country and share best practices and ideas and precedents as much as we can. So although the examples I gave happen to be the TDSB, by no means is that where our work is limited to. In terms of the cross engagement, I think, Steve, you said it really well with respect to one tool in the toolbox and trying to use all the different avenues that we have. I think it's valuable to share information about what's happening with trustees. If you have an existing relationship with your trustee, that's great. If not, reaching out and getting to know them, or reaching out to any trustees who have shown an interest in these matters. I think a really important step, if you're doing that, is to keep them posted on what's happening. To say, this is the problem I had. I'm going to be meeting with the principal next week. I'll update you after I spoke with the principal, and then saying, this is what happened when I met with the principal, and this is what they said they're going to do. Because I think that trustees will get a better understanding of the challenges facing the community if they see not just the problem, but all the challenges we face in trying to address those problems. And that then equips them better when meeting as a board or in doing other supervisory work over the schools to understand what is working and what isn't working. Because there's a lot of policies in place, but if people aren't familiar with what the policies are, if they aren't following what the policies are, it doesn't really matter. So the people who actually write and vote on those policies, if they don't understand how they translate into practice, then it's not going to do us much good.
Thank you, Naomi. Lots of other questions have come in, so I'm going to jump right into one that actually I'm going to ask Richard and Mark to consider taking this one on first. People have pointed out how the criminal code is limited in terms of what it can do to protect against hate speech. The threshold is very, very high, obviously, in the criminal code in terms of what's acceptable. So the question is, are there policy changes that we should be thinking about or advocating for, as a robust policy agenda that it's continually advocating for? Richard and Mark, what would you say in terms of, when you look at the legal landscape, are there policies or legislation that would dramatically change the situation if they were enacted? What's your sense in terms of the policies and laws you have to work with?
Mark, do you want to go first?
Well, I will, though I'm not optimistic about this. I think the initiative to provide for a civil remedy for hate speech, that is to bring back something that resembles the old Section 13 under the Canadian Human Rights Act would be helpful. Something that has a lower standard of proof than the criminal code standard of proof would be helpful. Something that deals directly with electronic communications like the internet would be helpful. I see the travails that the proposals to initiate something like that is having as reform is being contemplated. So I'm not optimistic, but I think something like that would be helpful.
Steve, if I may, I have three quick possible suggestions. The first one would be safe access legislation. That is something that can be done at the federal level, also at the provincial and municipal levels. That is to make sure that areas around institutions of identifiable groups have kind of a bubble around them in which you cannot have people demonstrating, because we saw what happened at the Bite a few months ago now. That was completely unacceptable. In Montreal, where I am today, the community had to go to court to have injunctions to ask for injunction to protect the community institutions. It started with 5 institutions, including the one where I am now, and it was extended, if I remember correctly, to 26 institutions, synagogues, community centers, and Jewish schools. So that's one thing that we're working on. Both at the federal level, the provincial level, and the municipal level. So that's one. The second thing is we need to stop and make clearer that the glorification of terrorism is not okay. There's legislation in the UK that may criminalize the use of symbols of terror groups. For example, the Hamas flag would be an example. The Australian Parliament is actually currently studying this. There's one bill in front of their House of Representatives. So there's work that can be done there. And the third thing is I'm not sure that our law enforcement is fully up to speed on hate speech, hate crimes, and how they impact the community and what they can do. There's already a lot in the books, lots of legislation, a lot of laws in the books. Not all of them are being used and enforced the way they should be. So there's a lot of work to be done in that sector as well. So those would be my 3 points. Thank you.
Thank you, Mark and Richard. Sorry, I had to change locations. I had technical difficulties with my laptop. One question that came up, and I'm not sure who to bounce this off of, but it's a bit of a technical question. Someone asked about the whole issue of the risk that a plaintiff takes on, and this was talked about by the panelists as well in the call. There are financial risks, there are reputational risks, there are all kinds of issues that come up potentially for someone who's thinking about engaging in litigation. So question number one is, and again, it's a technical question, is it required that a plaintiff in litigation have their identity be public? For example, is there a way for someone to bring forward litigation where they wouldn't necessarily have to be public about their identity? That's the first question. And the second question is around court costs and what's funded and not funded. So my understanding, and the panelists can correct me on this, is that legal task force members are taking on the work pro bono, but there are also court costs and financial risks that are being covered by UJA and CIJA funding. So in the event that there are disbursements that are required as part of the case, or in the event that there's a potential risk of court costs being awarded against the plaintiff or being leveled against the plaintiff. Can you speak to these two issues, both the issue of a plaintiff being anonymous or not public, but also the issue of the financial risk a plaintiff can take on and kind of how the LTF takes that into account?
So why don't I start, and then Richard may well supplement what I say on the issue of costs, and Naomi may well supplement what I have to say about confidentiality, because the situation may well be different when we're dealing with school-age kids who are minors rather than of the age of majority. So let me deal first with confidentiality, where you've got a plaintiff who is of the age of majority, so 18 or older. In a word or two, no, in any court case, they cannot keep their identities confidential. That is not really a thing. There is such a thing as confidentiality order, sealing orders, and so on and so forth in civil litigation. Generally, they don't extend to the identity of a party who is of the age of majority, other than in very, very, very limited contexts. And the Supreme Court of Canada clarified as recently as 2 or 3 years ago just how onerous the legal test is to obtain any kind of confidentiality type relief. The open court principle in Canada is a constitutional principle of law. You've got a right to know the case against you, and members of the public have a right to access litigation in the courts, which are public. So nobody, and again, I know sometimes this can be tough medicine, but this is actually one of the key hurdles that we've had to face. No, again, I'll repeat, you cannot keep your identity a secret or confidential as a general matter in civil litigation if you are of the age of majority. That is exactly why it's such a tough ask for students to be asked to put their name forward as plaintiffs. On the issue of funding, yes, members of the task force are putting in a lot of time on a pro bono basis. But there are two dimensions to cost exposure, if you will. First, in Ontario, civil litigation is conducted based on a loser pays system, which means that the losing party in civil litigation, as a default, will pay a portion of the legal costs, the reasonable legal fees and expenses of the winning party, which can add up pretty quickly. For that reason, we have been talking about, and in appropriate circumstances have been providing cost protection. Richard Marceau can speak more to the details of it as appropriate, although there are probably aspects of it that we cannot share. All I will say is that if there is a viable case and a case that ought to be brought, as a general principle, we will not let the risk of a downside costs order deter the case from being brought, and there is funding that may be available to assist with that. The second dimension is, although lawyers are contributing their time on a pro bono basis, it's a different matter when lawyers have to incur what we call disbursements. So that can be filing fees, it can be photocopy costs, it could be whatever, the overhead and other costs that lawyers themselves have to incur when they're acting in piece of litigation, and which normally are passed on to the client. When you're asking lawyers who are contributing large amounts of time pro bono to also eat their disbursements, which can be significant, it becomes a bit of a tall ask of the lawyer and a deterrent to having lawyers agree to act, especially if they're at smaller law firms, which are often the law firms that are free of conflicts and more willing to act. So again, on an appropriate basis, Richard can correct me if I'm wrong, there is funding available to assist lawyers in defraying the cost of those disbursements. We will not allow that to deter us from supporting pieces of litigation that ought to be brought and otherwise would be brought. So with that, Naomi may chime in on confidentiality and Richard may chime in on the funding piece.
Sure, I'll be quick, which is to say that when you have a plaintiff who's a minor, you do have an opportunity to commence the litigation using their initials and to be supervised by a litigation guardian, their parent. So on the formal statement of claim, you can do it anonymously. But the facts and the details and the allegations are part of a public document. So we, if we're assisting a student who is the only Jewish grade 6 student in, this particular Peel school or something else that makes them, a particular target of anti-Semitism, it also makes them readily identifiable. So we take the steps that we can to protect confidentiality as much as we can. There's a bit more available than there is for people who have reached the age of 18. But we have to be realistic with the plaintiffs when we speak with them about the risk. We don't want to sugarcoat it.
Steve, very, very quickly, there's a reason why Steve Frankel is a litigator and a good one at that. He very succinctly and nicely laid out the cost issue for when the LTF takes on litigation.
Okay. We're now at the top of the hour. I just want to conclude with where I started, which is, looking at all of the questions that have come through from the chat, there is overwhelming appreciation in our community for what this legal task force is doing. I can tell you, since October 7th, there have been so many reasons to be down about what's happening in the Jewish world, to be demoralized. One of the things I've consistently heard from community members, and we hear a lot from community members, is how encouraged they are by what the LTF is doing. Whether it's the campus cases, the UNRWA case, PSAC, and frankly, just the knowledge that we have this asset at our community's disposal, these incredible and talented people who are donating their time. And we know it takes a toll. And we know that the lawyers who've dedicated themselves on this panel, but also throughout the task force, have put a lot of late nights and long hours into this. So I just want to underscore both the appreciation for everyone on this call and all the LTF members who might be tuning in right now. Yeah, we see you and hear you, and we know that what you're doing is making a real difference. So thank you. And a call to everyone on this call: if you are a lawyer and you're not involved, or if you know a lawyer or someone who would like to be involved who has legal experience, please, we encourage you to reach out to us, ltf-war@cija.ca. That's ltf-war@cija.ca. Send an email. If you're a lawyer who's not involved, please consider getting involved. We're looking for people to donate their time across a whole range of legal fields. So you may think that what you have to offer isn't necessarily helpful. It actually could be very helpful. So please reach out and get involved. We'd love to have you involved. With that, we're going to conclude the call by just thanking everyone for joining us for this lunch hour. Thank you, everyone on the Legal Task Force, for your continued work to protect the rights of our community. And we wish everyone a wonderful rest of your day. Thank you.